Yes, the Hindu Marriage Act, 1955 allows for cruelty to be both physical and mental. 1. Section 13, 1, IA. Cruelty is a course of conduct that adversely affects one's spouse, and can be physical or mental, intentional or unintentional. 2. Factors that determine cruelty. These include the party's life, economic and social conditions, culture, and human values. 3. Physical cruelty. This is less ambiguous and is more a question of fact and degree. 4. Mental cruelty. This can be more difficult for courts to determine. For example, unintentionally waking a spouse up in the middle of the night may be mental cruelty. And 5. Each case is decided on its own merits. What is considered cruelty in one case may not be considered cruelty in another. The Supreme Court has held that men can also apply for divorce on grounds of cruelty. The Hindu Marriage Act of 1955 allows either spouse to seek divorce on the ground of cruelty, defined as any conduct that causes reasonable apprehension that it is harmful or injurious to live with the other spouse. 1. Definition. Cruelty can be physical or mental, intentional or unintentional, and is a subjective concept that varies in each case. 2. Examples. Some examples of cruelty include demanding dowry from the husband's parents with the husband's support, abusing the husband and his parents in foul language, heavy drunkenness or addiction to drugs, a husband having a love affair with another woman. 1. Procedure. To prove cruelty, you should maintain a record of incidents, including dates, descriptions, and the impact on your mental and physical health. File a divorce petition in the appropriate family court jurisdiction. 1. History. Cruelty was not a ground for divorce prior to 1976, but only a ground to seek judicial separation. The 1976 Amendment Act made cruelty a ground for divorce under Section 13, 1, IA. 2. Penalties. Cruelty is also a criminal offence under Section 498A of the Indian Penal Code, 1860. The person committing cruelty can be punished with imprisonment for up to 3 years, or with a fine, or both. Some landmark cases on cruelty under the Hindu Marriage Act, 1955 include 1. Maya Devi vs. Jagdish Prasad. The Supreme Court held that cruelty can be physical or mental, direct or indirect. The court also noted that the question of mental cruelty depends on the societal values, status, culture, and surroundings of the parties. 2. K. Srinivas Rao vs. Deepa. The Supreme Court granted a divorce to the husband after concluding that filing a false criminal complaint amounted to mental cruelty. And 3. Reema Aggarwal vs. Anupam and Oz. The court held that the husband of the second wife who marries her during the subsistence of earlier legal marriage is not the husband within the meaning of Section 498A. Other cases on cruelty under the Hindu Marriage Act include 1. Tapan Kumar Chakrabarti vs. SMT. Jyotsna Chakrabarti. 2. Madanlal Sharma vs. Santosh Sharma. 3. Santam Banerjee vs. Sachindra Nath Banerjee. 4. SMT. Pramila Bhatia vs. Vijay Kumar Bhatia. 5. Suman Kundra vs. Sanjeev Kundra. And 6. SMT. Surbhi Aggarwal vs. Sanjay Aggarwal. Cruelty under the Hindu Marriage Act includes 1. Physical violence. 2. Assault. 3. Any other form of harmful behavior that endangers the physical well-being of the victim. And 4. Continuous process of ill treatment or mental or physical torture to either of the spouse.